In 1961, in a Florida courtroom, a woman named Gwendolyn Hoyt sat in front of an all-male jury because Florida law only placed women on jury lists if they had voluntarily registered for jury service, while men were automatically eligible. She had killed her husband after years of a troubled marriage, and the all-male jury convicted her of second-degree murder, for which she received a sentence of not less than 20 years in the state prison. Not one bad judge, not one unlucky trial, not anything the sitcoms and the ladies' magazines ever showed you. It was written into the statute books, and the Supreme Court looked at it that year and said it was perfectly fine because a woman was still, in their words, the center of home and family life. Almost everything the advertisers sold you about the carefree working woman of the 1950s is a lie the ledgers do not back up. Number 25 kept a woman's paycheck out of her own hands entirely, and most of you have never heard it named. Number 13 decided who could sit in judgment of her, and number 1 is not a rule at all. It is the single line written on a bank form that made every other rule on this list possible. Subscribe now, because what you are about to hear is not the one-income paradise the sitcoms sold you. Let us count down. Number 25, the paycheck she could not deposit. The picture the magazines painted showed a woman free to work if she pleased, mistress of her own little earnings. The record is colder. In much of the country, well into the 1960s, a woman could not open a bank account in her own name without a man attached to it. She earned the money, she carried it home, and she could not put it anywhere it was safe. The reframe is the ugly part. The wage was hers, but the account had to be his, so the very act of saving depended on a husband's signature. Number 24. The want AD she was not allowed to answer. The advertisers loved the image of the bright girl scanning the paper for opportunity. The record is that the paper itself was split down the middle. Right up until the late 1960s, newspapers ran their help-wanted columns in 2 separate blocks, one headed male and one headed female, and the good-paying jobs sat almost entirely in the men's column. It was not until September 1968 that the Equal Employment Opportunity Commission declared sex-segregated help-wanted columns unlawful under Title VII of the Civil Rights Act of 1964. A woman could read the male listings all day. She simply was not meant to apply, and everyone knew it. Number 23, the marriage that cost her the job. The sitcom wedding ended in a happy home. For a great many working women, it ended a career on the spot. The rule was called the marriage bar, and it meant an employer could fire a single woman the day she married and refuse to hire a married one at all. At its height, marriage bars were imposed by a large majority of school boards and many office employers, especially in teaching and clerical work, though precise national percentages are not well documented. It faded through the 1950s, but for teachers, the discrimination was not fully outlawed until the Civil Rights Act of 1964. The shrewd, cruel logic was simple. A husband is supposed to support you now, so the job belongs to someone else. Number 22, the wings she lost the moment she said, "I do." The glamorous stewardess was the poster girl of the jet age. The record is that her job came with an expiration date stamped on her ring finger. Airlines in the 1950s hired young single women and required them to resign the instant they married. American Airlines listed unmarried status, right alongside pleasant disposition, as a formal qualification in December of 1953. The official reason was that a married woman might get pregnant and become unavailable. It took a 1965 grievance against Braniff to begin dismantling it, and the rule limped on into the 1970s. Number 21, the pay envelope that was thinner on purpose. The picture said a fair day's work earned a fair day's pay. The record from federal statistics is that in 1963, women working full-time earned about 59 to 60 cents for every dollar earned by men on average. Think about what that meant week to week. A woman doing clerical work might bring home $60 a week while the man at the next desk took $90 for identical labor. That gap was not illegal until the Equal Pay Act of 1963. And even then it carried loopholes wide enough to drive a car through. Same desk, same typewriter, $30 a week less, and the arithmetic ran against her for a lifetime. Number 20, the mortgage that pretended she earned nothing. The advertisers showed the happy couple signing for the little house with the picket fence. The record is that many banks and mortgage lenders discounted or refused to fully count a married woman's income in deciding what a couple could afford. The assumption was that she would soon leave work to have children, so her wages did not count. A woman could be pulling in real money month after month, and on the mortgage math it was as if she made zero. Her paycheck was real enough to spend and not real enough to borrow against. Number 19, the credit card in her husband's name. The magazine sold the modern woman with her own charge account, tapping into the new consumer paradise. The record is that a married woman could not get a card in her own name. She could only get one as Mrs., followed by her husband's name. And here is the sting. No matter how carefully she paid every bill, the credit history built up under him, not her. Years of perfect payments, and on paper she had no financial history at all. If he died or she divorced, she started from nothing. Number 18, the discount. They took off her word. The picture showed the eager saleslady, valued for her hustle. The record, according to the Smithsonian, is that some banks calculating a woman's credit limit would discount her wages by as much as 50%, on the theory that a woman's income was not to be trusted to keep coming. So a woman earning $80 a week was treated as though she earned $40. Her money was counted at half price, not because of anything she had done, but because of what a banker assumed she would do. Number 17, the co-signer she had to go find. The advertisers loved the picture of the independent single girl in the city. The record is that if she was single, divorced, or widowed and wanted a loan or a card, she usually had to bring a man along to sign for her, a father, a brother, an uncle, even a male friend. It did not matter if she out-earned every one of them. The bank wanted a masculine signature on the line before it would lend a working woman a dime. The humiliation was the point, and it was standard practice. Number 16, the questions no man was ever asked. The picture was a simple businesslike application. The record is a personal interrogation. A woman applying for credit could expect to be asked whether she was married and whether she planned to have children and whether she used birth control. Her private life was treated as a financial risk factor. A man walked in and filled out a form. A woman walked in and answered for her body and her marriage before anyone would talk numbers. None of it had a thing to do with whether she paid her bills. Number 15, the pregnancy that ended the paycheck. The picture showed the glowing expectant mother, cared for and secure. The record is that being pregnant was a firing offense with no protection at all. An employer could dismiss a woman the moment her condition showed, or refuse to hire her for the mere possibility of it, and it was entirely legal. That did not change until the Pregnancy Discrimination Act of 1978. And before then, a couple of Supreme Court rulings had actually said excluding pregnancy from protection was not sex discrimination. The very thing the whole domestic ideal was built around could cost a woman her income overnight. Number 14, the jury box she was excused from. The picture told women they were too delicate for the harsh world of the courts, that the exemption was a kindness. The record, laid bare in that Florida case, is that in a long list of states, a woman was not called for jury duty unless she went out of her way to volunteer, while every man was automatically enrolled. In one Florida county, the year before Gwendolyn Hoyt's trial, only 10 women's names went into a jury box holding 10,000. It was sold as a privilege, sparing her the filth of the courtroom. What it meant in practice was that women were judged by rooms full of men. Number 13, the seat she could not take in her own defense. This is the promise from number 14 come due. Gwendolyn Hoyt stood trial for killing her husband, argued she had been driven to it, and asked only that some women sit among her judges. The court said no. The Supreme Court in 1961 upheld it unanimously, reasoning that a woman was still the center of home and family life and could be spared the duty. The reframe is chilling. The same ideal that put her on a pedestal in the advertisements was used in a real courtroom to strip her of a jury of her peers. That ruling stood until 1975. Number 12, the higher interest they charged her for being a woman. The picture showed banks courting the modern female customer. The record is that as recently as 1974, lenders were legally allowed to charge a woman a higher interest rate or deny her outright if she could not produce a male cosigner. Same loan, same risk on paper, more expensive because of her sex. It was not until the Equal Credit Opportunity Act of that year that this became illegal. Before then, being a woman was itself treated as a surcharge, quietly added to the cost of every dollar she borrowed. Number 11, the business she could not finance. The advertisers loved the plucky woman with the little shop. The record is that a woman trying to start a business ran straight into the same wall as everyone else on this list. No credit in her own name, no loan without a man to vouch for her. Even after the 1974 law, the fight for women entrepreneurs to secure financing without a male cosigner dragged on until the Women's Business Ownership Act of 1988. For nearly 4 decades of the era people call the golden age of the family business, half the population was locked out of the capital to build one. Number 10, the raise that went to the man with a family. The picture said hard work was rewarded. The record is that employers openly paid men more on the stated theory that a man had a family to support and a woman was only working for pin money. It did not matter if she was a widow feeding 3 children on her own. The pay scale assumed her wages were a hobby. So the single mother and the bachelor doing the same job walked to different pay windows, and hers was the smaller one, justified out loud, with no shame at all. Number 9, the promotion reserved for someone else. The picture showed a ladder anyone could climb. The record is that the good jobs were sorted by sex before anyone was hired, thanks to those split want ads, and the ladder above the typing pool simply had no rungs for a woman. Management was a men's listing. A woman could run the office in everything but title and pay, training the young men who were promoted over her. The reframe is bitter. She was competent enough to teach the job and never once allowed to hold it. Number 8, the account he could empty without asking. The picture showed shared devotion and pooled resources. The record, in states with what were called head and master laws, is that a husband had legal control over jointly owned property and could sell it or borrow against it without his wife's consent. Louisiana's version of that rule was not struck down until a 1981 Supreme Court case. So a woman could contribute for years to what the law called community property and have no say when he decided to spend it. Her name on the deed did not mean her hand on the money. Number 7, the credit that died with her husband. The picture showed the comfortable widow, provided for. The record is that because all those years of good credit had accrued only to him, a woman who lost her husband often found it nearly impossible to get a loan at all. She had run the household budget flawlessly for decades, and the moment he was gone, she was a financial stranger. Grief arrived with an insult attached. The bank treated a 50-year-old widow like an 18-year-old with no record whatsoever. Number 6, the divorce that left her with nothing on paper. The picture, when the magazines admitted divorce existed, showed a tidy settlement. The record is that the same rule cut the same way after a divorce. The credit was his, the mortgage math had ignored her income, and the accounts had been in his name. A woman could walk out of a marriage she had helped build financially and discover she had no independent standing to rent, to borrow, or to start again. The system that made her invisible during the marriage kept her invisible after it. Number 5, the night shift she was forbidden to work. The picture called it protection, shielding the fragile woman from long or dangerous hours. The record is that so-called protective laws in many states barred women from certain jobs, certain overtime, and certain night work outright. It sounded chivalrous. What it did was hand the higher-paying shifts and the jobs with real overtime to men and lock women out, all dressed up as concern for her well-being. The protection protected her right out of the better money. Number 4, the training program that took men only. The picture showed opportunity opening for the ambitious. The record is that apprenticeships, management tracks, and company training programs routinely accepted men and turned women away as a matter of policy, not accident. A woman could not simply outwork the barrier. The door was locked before she reached it. And because those programs fed the promotions and the raises, being shut out at the entrance meant being shut out of everything downstream for an entire working life. Number 3, the Social Security that shortchanged her. The picture promised security in old age for everyone who worked. The record is that Social Security's design around a male breadwinner meant that many married women received benefits based on their husband's record rather than their own, and a working wife often received no more than the spousal benefit, even after years of contributions. She paid the tax like a worker and was counted like an afterthought. The very safety net sold as universal had her name written in smaller print. Number 2, the signature that was worth less than a man's. The picture showed the capable homemaker managing the household. The record, underneath every single item on this list, is that a woman's signature alone was treated as insufficient. On a loan, on a lease, on a business, on a credit application, the institutions of money simply did not accept that a woman's word bound her the way a man's bound him. That is why she needed the cosigner, the husband's name, the male relative at her elbow. Her competence was never the question. Her signature was. Here is the challenge. Before I tell you number 1, look back at the 24 rules you just heard. Ask yourself what they were really for. Not the bank, not the airline, not the jury box. Something underneath all of it. One small idea that every other rule was built to enforce. Number 1, the idea you have been circling this whole time, that in the eyes of the law and the bank, a woman was not a fully independent economic person, and her financial life was meant to run through a man. That is the single line beneath the account she could not open, the card in his name, the credit that died with him, the cosigner she had to fetch. It was not 24 separate cruelties. It was one belief, written out 24 different ways, and it took law after law across the 1960s and the 1970s to finally strike it down. Freedom, for the working woman of that era, was not a feeling. It was a signature the world finally agreed to accept as her own. Tell me the money rule your mother or grandmother actually lived under in the comments below. The account she couldn't open, the card that carried his name, the job she lost the week she married. I want to know whether she ever spoke about it as a hardship or just called it the way things were, and whether the freedom you take for granted today feels like a right you were born with, or a thing she had to be handed by a law with a date on it.